Michael Popak, Legal AF. Will any of the Trump kids take the Fifth Amendment against self-incrimination in the civil case that's coming up with their testimony scheduled this week? Will any of them take the Fifth Amendment? What does it mean? Have they waived the Fifth Amendment? And how does the Fifth Amendment work in a civil case? That's the purpose of this hot take. That's the breakout Legal AF law school session that I'm going to do right here. So let's start with who's who, what's what, and has anybody already taken the Fifth Amendment? So we've got Eric Trump, who's run more of the day-to-day operations for the Trump organization than probably the other two children since his father went to the White House. Don Jr. down in Florida. Ivanka Kushner now, who was a special advisor to the president, a White House job, and then, of course, also worked in the Trump organization. In fact, she at one point was considered to be the heir apparent, that she would take over as the titular head of the Trump organization, not the sons at a certain point. Certainly her mother, Ivana, was grooming her for that, and she had a very active role until about 2017 in the organization, and then Donald Trump himself. Let's go first to the scorecard as to who has already taken or waived the Fifth Amendment privilege against self-incrimination. Generally a criminal protection that you use in criminal cases, not in civil cases, and I'll tell you why in a minute. Eric Trump was deposed, a sworn question and answer under oath prior to a trial is called a deposition. He was deposed by the Office of Attorney General in New York, and he took the Fifth Amendment against self-incrimination 500 times. That's a bad thing in a civil case because there's a negative inference that the court or the jury can conclude based on the assertion of the Fifth Amendment privilege in a civil case. Can't be used against you in a court of law in a criminal case, but a civil case is another matter. Eric Trump already took the Fifth Amendment 500 times. We'll talk about next whether he's going to do that again when he's on the stand, or if the Attorney General even cares. Don Jr., on the other hand, he's a voluble guy. He likes to talk, and he didn't take the Fifth Amendment when he was deposed last summer. In fact, many of his clips were used in front of the judge at the start of the trial in opening statement by the Attorney General, because you're allowed to use clips from depositions and video depositions, and a lot of comments that were made by Don Jr., very interesting comments that were made by him, which I'll go over next, are fair game in the trial itself. For instance, in the let's just keep going with the scorecard, then I'll go back to Don Jr. Ivanka, there's a little bit of misreporting. I don't believe that she was actually deposed, question and answer under oath with a court reporter and the other side. I think she gave an interview, a sworn statement, slightly different, still sworn testimony to the Office of Attorney General. And there's no reporting out there that she took the Fifth Amendment then. So there's a waiver issue. We'll talk about that next. Trump, he, of course, has to be unique. He gave two depositions. The first deposition, he asserted the Fifth Amendment privilege, just like his son Eric, 400 times and never answered any questions whatsoever. Then he thought better of it after probably being advised by new counsel. That's not such a great thing to do in a civil case because a court can draw a negative inference that every time you take the Fifth Amendment, that you are guilty, if you will, liable, you are responsible for the item that's being asked of you. That's not a great thing. So he decided, I'll do it again. So he did it again. Letitia James, the New York Attorney General, actually took the deposition, and therefore you have a waiver argument. So now you know that's the scorecard of what happened before. What's going to happen now, I guess, is the question. So the fundamental premise of this hot take is that while it's an appropriate thing and usually an advisable thing for a defendant to take the Fifth Amendment against self-incrimination, unless he's just losing the case completely at that point against all odds, like this Sam Bankman-Fried and the crypto FTX case that's also going on in New York in federal court. And he's like, well, I'm way down on points. I got to go for a knockout. I'm going to go take the stand. Unless that, it's usually advisable not, and let the prosecutor, who has the burden of proof in a criminal case beyond a reasonable doubt, make their burden without you. In a civil case, completely different. You can take the Fifth Amendment. You're still allowed. Under a circumstance, though, it has to be a reasonable fear of prosecution in some criminal case somewhere. It can't just be If all the statute of limitations have run, if there's no prosecution that's pending against you, you can't just take the Fifth Amendment and not answer a question because you don't feel like it. A judge will intervene and say you got to answer that question. So first you have to establish you have a reasonable fear of prosecution and that the information that you're about to testify to could be used against you. But then in a civil case, whether it's a jury present or in this case, a bench trial with just the judge making the decisions, the judge can automatically, upon hearing I take the Fifth Amendment on that question, assume that the answer to that question is negative, is bad, adverse for the person answering the question. Here's an example. If Letitia James asks, let's say, Eric Trump, did you participate in the artificial inflation of assets on the books of Trump Organization to benefit your father? Yes or no? I take the Fifth Amendment against self-incrimination. The judge can conclude that he did participate in the cooking of the books at the Trump Organization. That's how that works. If I ask, if she throws in there, did you rob a bank on the corner of Broadway and 11th Street, in 2016, Mr. Trump? I take the Fifth Amendment. You can conclude that he robbed that bank. That's how that works. Adverse inference for Fifth Amendment assertion in civil cases. Now, how's that going to play out in the coming week with Donald Trump? Let's start with Eric Trump. He's the most interesting because he have very little fingernails. He's been biting his fingernails literally off during this case. Court watchers have observed that he's a nail biter, and I don't think there's a fingernail left on his hands. He took the Fifth Amendment 500 times and never fixed it. In other words, he never waived it. So he's got two choices. He either waives his Fifth Amendment privilege, which he could do, and answer the questions and deny he fudged the books or artificially inflated, or his dad did anything wrong, or they manipulated asset value in order to get tax breaks or to get more loans. He could just say point blank, no, that's not true, untrue. But he'll have to refute the sworn testimony already given of Alan Weisselberg, the chief financial officer who went to jail, Jeff McConney, the controller, financial controls person who reports to Alan Weisselberg, who almost went to jail, to lower level assistant vice presidents and other people within the organization who testified that they were instructed to inflate the assets and use formulas to inflate the assets. He'll have to swim against that tide, right? Those headwinds. Or he just takes the Fifth Amendment. If he takes the Fifth Amendment again, first the judge has to determine whether it's a reasonable assertion. So there'll be a breakout hearing. We'll report on it. There's no jury, so the jury doesn't have to be dismissed. The judge will say, all right, I want to hear evidence on this. What, sir, is the criminal case that you are worried about, that you have a reasonable belief that this information could be used against you in? Which is it? And I don't know what they'll say. The Manhattan District Attorney's case? The Manhattan District Attorney doesn't have a pending prosecution or investigation concerning financial misdealings of Trump Organization. Maybe they should. People are upset that they didn't, and they went the Stormy Daniels hush money cover-up route, but they don't. The feds don't seem that interested at the present time in any of these things, and some statute of limitations have already started to run. So they're going to have that. I don't think the judge Engoron is just going to let people willy-nilly assert the privilege without getting to the bottom and putting them through their paces of a proper foundation being established to assert the privilege. So let's assume he gets past that, and the judge says, all right, you want to assert the Fifth Amendment? Go ahead. So it's not the case where he just says Fifth Amendment and walks off and goes down to his local Starbucks and gets a coffee for the day. The prosecutors, the New York Attorney General, will ask every question required to elicit that Fifth Amendment answer, painstakingly, question by question, so that there's an adverse inference attached to each question. You can't just say, sir, if I ask you a whole bunch of questions, are you just going to take the Fifth Amendment? Yes. Okay, judge, no further questions. No, and I've done this in cases. You have to go through it methodically. You have your 100 questions. He has to assert it, not blanket. He has to assert it question by question. Because who knows? There might be a question in there. He says, no, I'm going to answer that one. Was your mother's maiden name blank? I don't know. You can take the Fifth Amendment on that one, or there's some things you can answer. So that's Eric Trump. He's going to have to make that decision. I don't know what he's going to do. My guess is he's going to waive the Fifth Amendment privilege and testify, but that's just my guess. Because you see the adverse inference problem if he doesn't. Don Jr., he's already waived his Fifth Amendment privilege. There's not going to be an assertion of Fifth Amendment, or shouldn't be, because he's already given a freewheeling deposition related to things, and I think he's cooked. Here's an example I was talking about Don Jr., and this is stuff that was played for the judge in opening statement a month ago when this case first opened. When particularly they asked him about the financial statements. And he said, I really wasn't involved with any of the preparation of any of the financial statements for more than a dozen years ever. That wasn't my job. And I may have contributed some information, but I never saw them and I never signed off on them. And he said, quote, well, I'm not an accountant, when they asked him about accounting principles, that his father, Donald Trump, attested that all the financial statements complied with generally accepted accounting principles, a term of art in the business, which means that it follows, appropriate accounting guidelines. He said, well, I'm not an accountant. This is Don Jr., but that they are generally accepted. Is that what generally accepted accounting principles mean? And then he laughed. And he started flirting. I'm not kidding. He started flirting with the person asking him the question. That's pretty much what I remember from Accounting 101. So, I'm sure I could come up with some creative stuff to kill time, but I'd be doing neither of us a favor in terms of educating ourselves. That was Trump Jr. about a key issue in the case. He was actually perked up more in the deposition when he figured out that one of the buildings that's at issue, that the New York Attorney General is trying to take away from the Trump family, 40 Wall Street. I've been to 40 Wall Street. I have friends that work in 40 Wall Street. He noticed that it was right over. You could see it from the conference room where he was giving the deposition, and of course he switched into the huckster P.T. Barnum that the family likes to adopt in trying to be the greatest salespeople on earth. And he actually said during his deposition the following, quote, I did all the leasing of that lovely building over your right shoulder, pointing to the window behind the examiner, and I'd be remiss as a Trump to not point out the lovely real estate that sits right there and I get to stare at all day, meaning during his deposition. And Colin Faraday, who's one of the lawyers to the New York Attorney General, said, noted for the record that the shades in the room, the window treatments were down, and he really couldn't see the building. I mean, there was just like a sliver of the building. But of course, Donald Trump Jr. Doubles down on that and says, they're not that down. I can still see probably about 30,000 square feet of a floor plate that, have you thought about moving office buildings? In other words, maybe you don't want to overlook 40 Wall Street. And Faraday replied, always a deal maker. And Donald Trump can't stop talking, Jr. And he says, listen, some shit you can't turn off, And that was Donald Trump Jr. So he's going to be a white knuckle event for the defense of Donald Trump because, his cocaine bear, Donald Trump Jr.'s cocaine bear videos that he does on TikTok and other places where he tries to defend his father and often backfires, he is completely unhinged. And so it's, like I said, it's going to be a white knuckle moment for the defense because he's almost incapable of being prepared. His father is incapable of being prepared. The only two I think could be prepared properly for testimony is maybe Eric and definitely Ivanka, because I think she's the smartest of all of the children. And then you've got Donald Trump. What about him? Well, he took the Fifth Amendment the first time around when he gave his deposition, and then he waived his Fifth Amendment. So when he's called next week, after all of these destabilizing moments that have been purposely chosen by the Attorney General, Michael Cohen destabilizing and making Donald Trump unhinged, then watching his children be publicly executed in a trial setting, if you will. And then Donald Trump gets to go. By that time, he's going to be about ready to blow. As I said on Legal AF, and to paraphrase John Larson, the great playwright and composer, the late, great John Larson, and one of his plays, tick, 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 boom. And that's the three Trump kids, and then Donald Trump going the following week after watching all of this. And who's just sitting watching as like a fighter pilot with situational awareness is Letitia James. You can see her in the courtroom. Every time they pan to Letitia James, we'll show one here. She's always got this amazing Cheshire Cat grin that only comes from somebody who is in complete command of everything that's going on. Donald Trump likes to consider himself the puppet master. There's only one puppet master in that room right now, and that is the New York Attorney General. So that's what's going to happen with the assertion of the Fifth Amendment. That's how Fifth Amendment works in civil cases. That's the foundation or the requirement that somebody asserting the Fifth Amendment has to prove to a judge before he's even able or she's able to assert the Fifth Amendment. And this is my handicapping and scorecard of who I think is and is not going to assert the Fifth Amendment as we lead into Eric, Don Jr., Ivanka, and Donald Trump's testimony. We'll watch it. We'll report as it happens during the week. One place, the Midas Touch YouTube channel. You knew that. This is where I do all of my hot takes, and you're here right now. So we do it here, and then we pull it all together. We curate the best 4 or 5 stories at the intersection of law, politics, and justice. And the leaders of Legal AF use our collective 75 years of experience, I said collective, as trial lawyers around the country to give you, from a prosecutor or defense standpoint, our analysis in good faith about what we're watching and where we think it takes us next. We don't blow smoke or sunshine.